Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. The Ninth Circuit decided to publish 4 cases in one day this week. I am up to the challenge, plus 2 more. Starting off with a head spinner because why not? Before we do, for all you crimmigration folks in the 11th Circuit, check out the dissents and really the general discussion on the issue in this week's case U.S.C. v. Laines, published by the 11th Circuit. It's about a lot of things not relevant to immigration, so thanks for alerting me to it, Mark Prada. As Mark notes, the judges seem to be making clear that the Chamu issue remains wide open in the 11th Circuit and might all come down to burdens. That is, that Florida's cocaine definition might be overbroad yet. Something that I, Mike Bastian, and Sui Chung, who actually litigated Chamu, and many others, have been saying for a long time. Give the Laines decision a read if you're trying to get into it. Maybe check out Chamu too from episode 92, if only to remember what's going on with this very complicated issue. Thanks, Mark, and 1 million congrats to Sui Chung for her well-earned 2023 Lisa Brodiaga Ayala Award. See you all at the conference. And see you all with these cases. The first case, Koonwaiyou v. Blinken, published by the Ninth Circuit on June 7th, 2023. Why not start off with a strange one? The very complicated case about what exactly is a national of the United States and who qualifies. It's written by recent appointee Judge Ko, one of the first, if not first, authored precedential immigration decisions that she has done. And you know it's going to be a complicated one because it begins by explaining that in 1986, Congress amended the Immigration Nationality Act to make individuals born to only one non-citizen national parent outside the United States and American Samoa eligible to become, quote, nationals but not citizens of the United States at birth, end quote. Congress explained that this expanded eligibility was open to those, quote, born before, on, or after the date, end quote, that the 1986 amendments were enacted. The question here is whether, quote, those qualifying under, but born before the 1986 amendments received the same national status as those born on or after the amendments' enactment, end quote. Still following? I barely am. The district court said they don't. Such individuals are not nationals of the United States. The Ninth Circuit said they do. Let's step back. Quote, all citizens of the United States are also nationals. However, some nationals are not citizens. Traditionally, only persons born in territories of the United States were non-citizen nationals, end quote. But today, even those people are citizens, except those born on American Samoa. Quote, those with ties to American Samoa are the only group still eligible for non-citizen national status, end quote. That's who nationals are. What's the difference? Well, as non-citizens, quote, American Samoans are denied the right to vote, the right to run for elective federal or state office outside of American Samoa, and the right to serve on federal and state juries, end quote. And they can't get some federal jobs. They can do and get pretty much everything else. Not the worst trade-off ever, right? As a person who was literally called for jury duty this week. Mr. Koonwaiyou is, you guessed it, Samoan. His father is Western Samoan, while his mother is American Samoan. He was born in 1967. His mother is now a non-citizen national, but she only became eligible for that once the law changed in 1986, and she didn't obtain that status, it seems, for a few more years. Mr. Koonwaiyou argued that this made him a non-citizen national as well, but U.S.C. denied his application. The district court dismissed his lawsuit, believing it determinative that his, quote, mother's status as a national of the United States commenced on the date it was conferred and was not retroactive to her date of birth, end quote. The Ninth Circuit, though, agreed with Mr. Koonwaiyou. Was the mother a national at birth, even though she didn't become eligible to become a national and didn't actually become a national until 1986 and afterwards? Yes, the law is retroactive, said the Ninth Circuit. After all, the 1986 amendments say that those that qualify, quote, shall be nationals but not citizens of the United States at birth, end quote. The Ninth Circuit conducted some quite complicated statutory interpretation, but that's essentially it. Reviewing various sources and the structure of the statute, the court read, quote, at birth, end quote, to mean just that. Of course, I'm not going to let it just end there. Is it retroactive to people like Mr. Koonwaiyou's mother? Well, a law is retroactive if, quote, the new provision attaches new legal consequences to events completed before its enactment, end quote. And usually laws aren't deemed retroactive. It's usually unfair to do so. But in an uncodified version of the 1986 amendment, Congress made expressly clear that people like Mr. Koonwaiyou's mother born before the amendments qualified. True, that wasn't codified as law, but also it, quote, distinguishes the 1986 amendments from similar statutes that clearly specify Congress's intent to limit retroactivity to a particular class of individuals, end quote. Plus, even though uncodified statutes don't make it into the U.S. Code, they are apparently, quote, binding law, end quote. Who knew? The court, of course. What hell-on-earth legislative history type assignment will I receive from Ira Kurzban when he finds out that uncodified sections of congressional legislation are fair game? I'm sure he already knows, but also, hopefully he doesn't listen to the podcast. Plus, again, said the court, the at-birth language is right there in the amendment. Should you ever get this very niche issue, quote, Congress created a scheme where all those eligible under Section 14084 receive the same status, but those born before the amendment's enactment are required to prove their eligibility before their status is considered to be conferred upon them, end quote. But once they prove it, as Mr. Koonwaiyou's mother did, they receive it from birth. Looking to similar citizenship statutes that appear to have limiting language, the court was satisfied with its reading of the 1986 amendments, employing the statutory interpretation presumption that Congress intended to omit the temporally limiting language. And in any event, quote, the parties agree that Congress enacted the 1986 amendments to expand the class of American Samoans eligible to become non-citizen nationals to include those born outside the United States to only one non-citizen national parent, end quote. So why limit the reach now? And as such, and albeit retroactively, as Mr. Koonwaiyou's mother is considered a national at birth, Mr. Koonwaiyou is a national too. See you not at jury duty, Mr. Koonwaiyou. And congratulations to Aaron Corthias, Matt Adams, Margot Adams, and Tim Warden-Hertz of the Northwest Immigrant Rights Project for plaintiff appellant. And that is Koonwaiyou v. Blinken. Okay. Next, Rodriguez-Zuniga v. Garland, published by the Ninth Circuit on June 7th, 2023. This case is about asylum and past persecution. Judge Gilman, from the Sixth Circuit, sitting by designation, dissented. Miss Rodriguez-Zuniga and her son Nelson are from Guatemala and entered the United States without authorization. They applied for asylum and related relief in removal proceedings. As the basis, Ms. Rodriguez-Zuniga claimed that she had suffered past persecution by gangs based on her political opinion and or her membership in at least one of 3 purported particular social groups: Guatemalan families that lack an immediate family male protector, Guatemalan women, and or immediate family members of Doris Amanda Rodriguez-Zuniga. Ms. Rodriguez-Zuniga testified that just a few months before she came to the United States, she had gone to a bank to withdraw about $150 that her husband in the U.S. had sent her and regularly sent to her. As she was leaving, a woman who she believes is part of a gang threatened to harm her or her son if she didn't give her the money. The woman said that she was going to, quote, pay for it, end quote. Not only that, but Ms. Rodriguez-Zuniga's female cousin had been killed for similar reasons, as had her cousin's son, although Ms. Rodriguez-Zuniga didn't know for sure whether it was the gangs that killed the son. The immigration judge and the BIA denied, basically by making a no-nexus finding. The Ninth Circuit affirmed in a split decision. And the majority really went in depth in its reasoning. But really, it only needed one, right? You only need one reason to deny. So addressing the Ninth Circuit majority's last reason first. Even assuming that political opinion held or those particular social groups cognizable, the Ninth Circuit didn't think that those were one central reason or even a reason for withholding of removal, as required in the Ninth Circuit, for the attempted robbery, or Ms. Rodriguez-Zuniga's fears in the future. For what it's worth, it looks like the IJ and the BIA accepted that the group of, quote, Guatemalan women, end quote, was a cognizable particular social group. And that's something worth citing right there. Indeed, the IJ held that, quote, Guatemalan women were a particular social group because of the high level of violence committed against Guatemalan women and their need for specialized protection, indicating they are viewed as a distinct group as compared to the general population in Guatemala, end quote. Worth citing too. But again, not the reasons of the Ninth Circuit for the attempted robbery. The Ninth Circuit did not stop there, though, and shut down a different particular social group for posterity. The Ninth Circuit agreed that the group Guatemalan families that lack an immediate family male protector was not cognizable because the evidence did not establish that such families, quote, are perceived as a group by society, end quote. Important because according to Ms. Rodriguez-Zuniga, the robber told her that this was why she was targeting her, because she had family in the United States. But because the group isn't cognizable, it doesn't matter. On political opinion, the Ninth Circuit agreed that Ms. Rodriguez-Zuniga did not present evidence to show that she actually expressed a political opinion. Refusing to hand over the money didn't count because it was not a, quote, sufficiently conscious and deliberate expression of a political opinion, end quote. The Ninth Circuit believed that instead, Ms. Rodriguez-Zuniga was simply reacting to being robbed. And to the court, quote, most people who resist criminal activity directed towards them do so for obvious non-political self-interested reasons. They don't want to be a victim of a crime, end quote. Turning to that family-based group a bit more, even if it was cognizable, the Ninth Circuit didn't see a nexus sufficient for asylum or even withholding of removal. Echoing former Attorney General Barr, the Ninth Circuit held that, quote, to establish a nexus between her family membership and her harm, Ms. Rodriguez-Zuniga must show that her family membership was a reason motivating the robber to target her, end quote. Now true, in Ayala v. Sessions, the Ninth Circuit held that, quote, economic extortion on the basis of a protected characteristic can constitute persecution, end quote. Economic extortion on the basis of a protected characteristic can constitute persecution. I repeated that twice. But the Ninth Circuit reads Ayala as an extortion plus case, that the person was targeted independently of simply a desire for money, even though the money was also desired. Not so here, but that's your standard for the future in the Ninth Circuit. Extortion plus. On Convention Against Torture Protection, the Ninth Circuit believed much of the issue waived or unsupported by the record. The majority then turned to the dissent, and the dissent alone, for 6 pages, and said a lot of things, including, quote, something has gone terribly wrong when judges conclude that relief for persecution and torture is mandated just because someone was the victim of a brief and failed robbery attempt in their home country, end quote. The Ninth Circuit majority denied. To the dissent briefly. In total, this is a 57-page decision with a, quote, vigorous dissent, end quote, from Judge Gilman. I simply cannot do Judge Gilman's 22-page dissent justice, but it's worth a read, if only to understand the nearly opposite views on many issues just discussed of a sizable portion of the Ninth Circuit. And of course, to review if Judge Gilman is ever on your panel in the Ninth or Sixth Circuit. And remember, explains the majority in a footnote, Ninth Circuit case law, quote, permits someone to establish a nexus when one of the persecutor's motivations is financial, so long as another motivation, either the central reason or simply a reason, depending on what claim is being pressed, is actually motivating the persecutor and is based on a victim's protected characteristic, end quote. This wasn't a mixed motive case at all, explained the majority, speaking to the dissent and to all of you. If it was, things might have been different. And that is Rodriguez-Zuniga v. Garland. Continuing on with the Ninth Circuit from June 7th, because that was the Ninth Circuit's day, we have Arizmendi-Medina v. Garland. So Judge Gilman just dissented, right? He wrote the majority here, with Judge Forrest dissenting. This case is about due process. Mr. Arizmendi-Medina is an asylum seeker from Mexico, placed in detained removal proceedings in my backyard, Otay Mesa. After paying a $25,000 bond to be released from ICE detention, which to be honest with you seems like quite the bond for someone with no criminal record, Mr. Arizmendi-Medina's case was transferred to the non-detained San Diego Immigration Court, my front yard. And wouldn't you know it, at the first non-detained hearing, Mr. Arizmendi-Medina told the judge that he, quote, had not yet been able to hire an attorney, stating that his $25,000 bond was high for him, and that he was still looking for funds to hire an attorney, end quote. But the IJ denied a continuance, reasoning that Mr. Arizmendi-Medina had had two while in immigration prison. The IJ then sustained the charge of removability. During the pro se questioning, Mr. Arizmendi-Medina, quote, revealed that he was afraid to return to Mexico because he had been mugged and beaten in the streets when last there, end quote. The IJ had a Form I-589 asylum application given to him and said that it must be completed and filed by the next hearing, set for less than 2 months later. Mr. Arizmendi-Medina did indeed eventually hire an attorney, the same one who represented him on petition for review here. But it took a while for Mr. Arizmendi-Medina to retain, because he didn't have much money. At the next hearing, because she had only just been retained, the attorney requested a, quote, brief continuance, end quote. The IJ denied the continuance, and then denied the asylum application as abandoned, even though this was a master calendar hearing. Seems like that was actually the first time that counsel had been informed by anyone that an asylum application was due that day. Thinking on her toes, counsel then said, quote, Your Honor, if today is the deadline, we would ask that you permit a window filing, end quote, which would have allowed the attorney to, quote, complete and submit the application before the court closed for the day, end quote. That request was denied too. The attorney, quote, next requested that the IJ allow her to submit the application while the IJ was still on the bench that day. This request was also rejected, with the IJ declaring that it was due this morning, end quote. The IJ denied the asylum application as abandoned, denied post-conclusion voluntary departure, and ordered Mr. Arizmendi-Medina removed. The BIA agreed with the IJ. The Ninth Circuit majority did not. It believed that under these circumstances, the IJ denied Mr. Arizmendi-Medina due process. Although IJs have discretion to set deadlines and time limits, they, quote, may not, when setting and enforcing deadlines, proceed in a manner that deprives a non-citizen of due process, end quote. In this case, explained the court, what the IJ did deprived Mr. Arizmendi-Medina of a full and fair opportunity to present his case. The reasons, explained the court, were threefold. First, the Ninth Circuit believed that the IJ did not, quote, clearly communicate deadlines, end quote. To the court, the deadline the IJ set could have just as easily been for Mr. Arizmendi-Medina to find an attorney. The transcript was actually kind of ambiguous. And in any event, quote, even if the IJ expected the relief application to be completed on December 18, 2018, the IJ did not clearly state the dire consequences of failing to abide by such a deadline, end quote. The IJ simply said that without an application, asylum was likely to be deemed abandoned. The IJ's lack of clarity to the court was in contrast to the BIA's exceptionally harsh decision on filing deadlines in matter of RCR. Harsh as that decision is, and check out episode 19, the IJ was crystal clear in that decision. Not so here. Plus, explained the Ninth Circuit, to the extent there was a deadline, it was December 18, 2018. At the height of Jeff Sessions pressuring IJs to complete cases, I might add. But the attorney tried to comply with that deadline twice, either by filing the application at the court's window that day, or even later that day while the IJ was still on the bench. The IJ only said it was due that morning at the hearing itself, not before. As the Ninth Circuit explained decades ago in a slightly different context in Jarzano v. INS, quote, it is accepted practice for courts to give tardy litigants a second chance by putting them at the end of the calendar, and that so long as the IJ is there on other business and the delay is short, it is an abuse of discretion to treat a slightly late appearance as a non-appearance, end quote. Very importantly, this was a master calendar hearing. This was not an individual merits hearing. The IJ had not set this hearing to adjudicate the asylum application. So why so serious, Judge? Asked the court, in so many words. Quote, no delay at all would have occurred in the adjudication of the merits if Mr. Arizmendi-Medina had been allowed to submit his relief application to the IJ at any time on December 18, 2018, let alone while the IJ was still on the bench, end quote. Emphasis by the court. And for use in all your continuance appeals, quote, a myopic insistence upon expeditiousness will not justify the denial of a meritorious request for delay, especially where the denial impairs the petitioner's statutory rights, end quote. As if speaking directly into the ears of the former Attorney General, the court reminded that, quote, an immigrant's rights to have his or her case heard should not be sacrificed because of the immigration judge's heavy caseload, end quote. Finally, and a bit relatedly, the IJ erred in not granting a continuance, said the Ninth Circuit. It was an abuse of the IJ's discretion. In the Ninth Circuit, that requires a balance of the following factors. 1. The nature of the evidence excluded as a result of the denial of the continuance. 2. The reasonableness of the immigrant's conduct. 3. The inconvenience to the court. And 4. The number of continuances previously granted. As already discussed, the court saw all totally or somewhat favoring Mr. Arizmendi-Medina. Even the third factor, quote, the IJ was hardly inconvenienced at all, end quote. Counsel would have filed it that day if given the opportunity, and 2 prior short pro se continuances in the detained setting weren't overly probative to the Ninth Circuit. Judge Forrest, in dissent, agreed with the immigration judge. But Mr. Arizmendi-Medina has the majority. Case remanded, presumably, for an asylum application to be filed. Therefore, super congratulations for all of it to my new LinkedIn friend, Shannon Englert, for petitioner. If this decision is any indication, I suspect you got a little more than you signed up for all those years ago. Well fought. And that is Arizmendi-Medina v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. Rounding out the Ninth Circuit, we have Zhovtonizhko v. Garland, published by the Ninth Circuit on June 7th, of course, 2023. It's a relatively short crimmigration decision. And it's a fun one. Mr. Zhovtonizhko is from Ukraine. Looks like Mr. Zhovtonizhko came to the United States as a refugee in 1992 when the USSR fell and is now a lawful permanent resident. However, in 2016 and then again in 2018, he was convicted of attempting to elude police in violation of Washington Revised Code Section 46.61.024. Two crimes involving moral turpitude make an LPR removable. So if this statute is a CIMT, well. So let's get right to the analysis. Quote, "The facts underlying these convictions are not relevant for our purposes." End quote. Indeed, Judge Bybee. The IJ had held that the convictions were CIMTs. After all, the BIA had said so in matter of Ruiz-Lopez. But that decision adjudicated a prior version of the statute, promulgated in 1983, which in relevant part included a statutory requirement that the defendant, quote, drives his vehicle in a manner indicating a wanton or willful disregard for the lives or property of others, end quote. In 2003, though, apparently trying to make more eluding of police criminal, Washington eliminated that requirement. Now it is sufficient to convict if the person fails to immediately stop for police while attempting to elude them, quote, in a reckless manner, end quote. For every action, there is sometimes an opposite and not always equal reaction. Here at least, though, that statutory change made all the difference. The BIA had disagreed below, realizing the issue but holding that, quote, recklessness is a sufficiently culpable mental state for moral turpitude purposes, end quote. Is it, though? Sometimes, if the risk of harm or reprehensible conduct is sufficiently high, that's a matter of woo, to me. In fact, it's all me. That wasn't really the rationale employed by the Ninth Circuit here. Their rationale is as follows, quote, the Washington Supreme Court has held that operating a motor vehicle in a reckless manner means operating it in a rash or heedless manner, indifferent to the consequences, end quote. And in that same Washington Supreme Court decision, directly contrary to the BIA it seems, the Washington Supreme Court held that, quote, reckless manner cannot be defined as willful or wanton disregard for the safety of persons or property, end quote. Naturally, the Washington Supreme Court's interpretation of Washington statutes trumps the BIA on the elements of the offense. Heck, it even trumps the Ninth Circuit. Washington appellate courts have similarly, quote, held that the 2003 change in the eluding police statute reduced the mental state necessary to prove the crime, end quote. Relying, therefore, on matter of Ruiz-Lopez as if nothing had changed was not the correct thing to do. One appellate court in Washington has actually gone so far as to hold that, quote, it is now well settled in Washington that driving in a reckless manner is a lower mental state than the willful or wanton mental state for reckless driving, end quote. To the Ninth Circuit, the BIA, quote, did not consider any of the implications, end quote, of the 2003 change in the statute. The phrase reckless manner, as used in the new statute, is not the same as recklessness, nor does it necessarily require reprehensible conduct. Quote, The BIA's perfunctory construction of the crime's elements necessarily created a flawed foundation for its subsequent categorical analysis, end quote. So the matter was sent back for new analysis. Might I direct the BIA to matter of Wu? And congratulations, Christopher P. Stanislawski and Lila Kang of Northwest Immigrant Rights Project for petitioner. Y'all had a week at Northwest Immigrant. Also, that's the Ninth Circuit's fourth decision for the night. I'm going to go watch the Heat beat the Denver Nuggets in the second half. And that is Zhovtonizhko v. Garland. Postscript. The Miami Heat did not beat the Denver Nuggets on June 7th. Next is Ponce v. Garland, published by the Fifth Circuit on June 9th, 2023. Also a loss for the Miami Heat. This case is also about the categorical approach, namely child abuse. Mr. Ponce is from El Salvador and came to the United States as a child. He received LPR status in 2014 as a child. While in high school, quote, he inappropriately touched his younger female relative, end quote. This led to a guilty plea of having violated Texas Penal Code Section 22.04a, injury to a child in the third degree. Mr. Ponce received 5 years of deferred adjudication, counseling, and 200 hours of community service. Might not be a conviction under Texas law, I'm not quite sure. But DHS said it was a conviction under immigration law, and that it was both a crime of child abuse and a CIMT committed within 5 years of adjusting to LPR status, both of which would make Mr. Ponce removable. The IJ and the BIA agreed that the event was a conviction, and that it was a crime of child abuse as defined at INA Section 237A2EI, and then denied Mr. Ponce's application for asylum and related relief. As Mark Prada and I will discuss on a National Lawyer Guild's virtual panel next week, there are quite a few petitions for certiorari pending before the Supreme Court regarding the scope of INA Section 237A2EI, and just what a crime of child abuse, abandonment, or neglect is. If you'd like to go down that winding path, join our panel discussion, or check out the Ninth Circuit's Diaz-Rodriguez v. Garland decisions from episodes 137 and 72. But for now, and for this decision, the BIA's definition of that phrase governs. Under the BIA's matter of Velazquez-Herrera decision, quote, child abuse means any offense involving an intentional, knowing, reckless, or criminally negligent act or omission that constitutes maltreatment of a child or that impairs a child's physical or mental well-being, including sexual abuse or exploitation, end quote. That's a broad and kind of vague definition, no? Would be a shame if the Supreme Court were to vacate Chevron deference next term, wouldn't it, BIA? The Texas statute here, in turn, can result in conviction if someone abuses a disabled or elderly person. Of course, not a good thing to do, but also not a crime of child abuse, making the statute overbroad. So if this Texas statute is not divisible as to the victim harmed, Mr. Ponce wins and is not removable, no matter what he actually did. That's how the categorical approach works. Unfortunately for Mr. Ponce, the Fifth Circuit already addressed this very issue against the argument in Monsoniem v. Garland, episode 111, and probably after Mr. Ponce filed his petition for review. Looking to the plea agreement then, the BIA and the Fifth Circuit saw the victim was a child under 14 years old, so that's pretty much it for that argument. Although the statutory text of the crime seems to indicate that the statute is not divisible, Monsoniem said what it said. Go review that decision for why it said it. But Mr. Ponce had a backup argument. The Texas statute criminalizes infliction of serious bodily injury, serious mental deficiency, or mere bodily injury. Mr. Ponce argued that mere bodily injury isn't abuse, as the BIA has defined it. Now, preliminarily, the Fifth Circuit was all ready to reject this argument because it seems that Mr. Ponce never made it before the BIA, even in a motion to reconsider. But for the Fifth Circuit, the Supreme Court's recent Santos-Zachariah decision now makes it such that motions to reconsider aren't required. Lucky break for Mr. Ponce. So the Fifth Circuit reviewed the argument, but it still didn't agree with it. Applying the realistic probability test in a way that no other court does, and in the removability context to boot, the Fifth Circuit required that Mr. Ponce find a case where Texas actually applies the statute overbroad. Don't get me wrong, it's not completely clear that the statutory text is overbroad on this issue, that is, the amount of harm required, but I note the Fifth Circuit's outlier framework, as I always do. Anyway, Mr. Ponce did point to a case where the Texas First District Appellate Court held that, quote, any physical pain, however minor, will suffice to establish physical injury, end quote, under this Texas statute. Is that really child abuse? Mr. Ponce argued. Not only that, put forth Mr. Ponce, but, quote, the injuries described in some Texas cases, such as ant bites and pinching or rubbing a child's face, are so temporary that they should not be considered child abuse, because they do not rise to the level of impairment of a child's physical or mental well-being, end quote. The problem is that the Fifth Circuit sees all of this as also matching the generic BIA definition of child abuse. Also, it seems that the Fifth Circuit reads that first DCA quote as out-of-context dicta, and looking to the underlying conduct of that case, believed that the quote striking a child and pulling a child's hair, end quote, at issue therein would also qualify as child abuse. So Mr. Ponce did not, in fact, find a case, and so he did not succeed. Looks like Mr. Ponce didn't challenge the denial of relief on petition for review, so the Fifth Circuit affirmed his removal order. And that is Ponce v. Garland. We conclude with Pacheco-Moran v. Garland, published by the Eighth Circuit on June 5th, 2023. This case is about asylum and past persecution. Mr. Pacheco-Moran has been in the United States for a long time. Among other things, surely, he's from Mexico, he's gay, and he's married to a man. He first entered the U.S. without authorization in 1991, and then again in 1996, but he wasn't placed in removal proceedings until at least 2012. He never applied for asylum before then, nor did he really seem to pursue asylum at his first removal hearing, at least not as his primary form of relief. After all, he was about 16 years or so past the one-year filing deadline. Instead, Mr. Pacheco-Moran's attorney stated that he would seek a U visa classification because he had been the victim of a felony assault in Compton, California in 1996. But police had thus far not certified Mr. Pacheco-Moran as required for U visa status. The immigration judge granted a continuance. The IJ ordered that an asylum application and memorandum be filed at the next hearing, as that was the alternative basis for relief, and the only basis identified for which the IJ had authority to grant. If, after all, USCIS denied the U visa classification, there's not anything for the IJ to do on that U visa application. USCIS has all the control there, I believe. So asylum. Mr. Pacheco-Moran claimed it based on the particular social group of homosexual men in Mexico and married homosexual men in Mexico. And he claimed that changed circumstances of his marriage since entering in 96 should count as changed circumstances to excuse the one-year filing deadline. The basis for the claim, though, was primarily things that had happened to Mr. Pacheco-Moran when he was a teenager in Mexico many years ago. His father would hit him with a belt almost every day, realizing he was gay. Quote, once after he locked himself in a bathroom, he started pouring water on him with a hose, and said he would pour water on him until he drowned, end quote. Mr. Pacheco-Moran was made fun of horribly. Schoolmates beat him and did terrible things to him. He considered suicide at 11 or 12 years old. He was last assaulted at 13 or 14 years old in the late 1980s. He met and married his husband in the United States. They married in August 2013. Recently, his sister in Mexico told him that a classmate was murdered in 2016. Mr. Pacheco-Moran believes that that was because he was gay. Mr. Pacheco-Moran has since undergone psychotherapy to cope with his past and the stress of what might occur if he loses his case. The immigration judge accepted the one-year deadline argument, finding that Mr. Pacheco-Moran's marriage to a man, during proceedings it appears, was a changed circumstance that therefore made his asylum application timely. Well done, everybody. But we all know that that's not why he was harmed in the past as a boy. It wasn't because he was married to a man, of course. So that's a problem. That meant to the IJ that Mr. Pacheco-Moran hadn't suffered past persecution on account of that reason, meaning that he needed to establish a well-founded fear of future persecution rather than DHS having to rebut his presumptively well-founded fear. And this, the IJ concluded, Mr. Pacheco-Moran did not do. The IJ believed the record lacking, and in any event that Mr. Pacheco-Moran could live in Mexico City, quote, a place where there is ample evidence a married gay man would not suffer persecution, end quote. The BIA affirmed. The Eighth Circuit affirmed all of that without much analysis. It relied essentially on lots of precedent, holding that the BIA's decisions on the issue are due deference. The Eighth Circuit gave more analysis to the second related ground for asylum, Mr. Pacheco-Moran's status as a homosexual man in Mexico. But Mr. Pacheco-Moran has a big problem there, right? That claim would appear time-barred, even if it could be the basis for a past persecution finding, because it's not tethered to his marriage. Mr. Pacheco-Moran tried to get around the one-year deadline for this claim by arguing that either individually or together, his marriage to his husband in 2013, the murder of his friend, and or his recent mental health and PTSD should make his claim timely. All courts disagreed. And it's actually worse because under Eighth Circuit precedent, the court can't even review a finding of the BIA not to excuse the time bar for asylum. That's the Eighth Circuit's reading of INA Section 208A3. The Ninth Circuit has apparently said otherwise, but the Eighth Circuit was not too concerned about that. More interesting was Mr. Pacheco-Moran's very smart argument that now, after the Supreme Court's decision in Guerrero-Lasprilla, whether agreed facts meet a legal standard is in fact a question of law that circuits must review. And here, everyone agreed that Mr. Pacheco-Moran married a man, that his friend was killed, and that he recently began suffering mental health issues. The facts are not in dispute. The problem is, said the Eighth Circuit, is that INA Section 208A3 is clear, and to read Guerrero-Lasprilla as applying to it would strip that section of, quote, all effect, contrary to established principles of statutory construction, end quote. There's a devastating quote for oil to use in the similar percolating post-Patel litigations. I recommend that you do not. So anyway, asylum's out. Withholding of removal has an even higher evidentiary burden, and here too the Eighth Circuit affirmed the agency. The IJ didn't believe that what Mr. Pacheco-Moran suffered all those years ago actually rose to the level of past persecution, even together. But putting that aside a bit to the BIA and the Eighth Circuit, at a minimum, there was nothing reversible with the IJ's finding that Mr. Pacheco-Moran could go live safe enough in Mexico City. That's actually where Mr. Pacheco-Moran's husband is originally from, reasoned to the court, and Mexico City, quote, has taken the lead, taking measures to protect the rights of the LGBT population, end quote. Mr. Pacheco-Moran urged remand for consideration of a third particular social group, Mexicans perceived to be against Catholicism, presumably because of the same-sex marriage. Way to think outside the box, counsel. Problem for this case, but not the next case that comes around, is that Mr. Pacheco-Moran never brought this basis before the IJ, at least not clearly enough for the Eighth Circuit to hold that it was sufficiently raised. Close case on exhaustion, though, if you ask me. Finally, in a decision that doesn't seem to quit, the Eighth Circuit affirmed the IJ's denial of a final continuance that Mr. Pacheco-Moran sought in an effort to finally get the necessary certification from police so he could apply for that U visa based on the 1996 assault in Compton. Seems that the Los Angeles police couldn't find the file for a long time, but that eventually Mr. Pacheco-Moran obtained the certification that he had cooperated all the way back in 96 after being a victim of felonious assault. So Mr. Pacheco-Moran wanted to file his U visa application with USCIS, making the request, it seems, just after his individual hearing. Kind of weird if that's what happened. But the IJ denied a continuance, as DHS had opposed it. Right, okay, it looks like there was a merits hearing, but no decision yet, and then Mr. Pacheco-Moran filed the U visa application with USCIS, with the written decision pending. That's when he moved for a continuance. Not the best procedural history there, but also He was kind of being held hostage by the LA Police Department's refusal to certify and inability to find his file. Anyway, the continuance was denied and the 8th Circuit affirmed. As the 8th Circuit reasoned, DHS had opposed the continuance. No visa application was pending before the individual hearing, and to the court, the prospect of a U visa being granted was speculative. Even though Mr. Pacheco Moran eventually did get that certification, and there don't appear to be issues of discretion in his case. It seems that no one wanted to forgive Mr. Pacheco Moran for his, quote, 20-year delay in filing a U visa application, end quote. Okay, no continuance, said Mr. Pacheco Moran. But what about the fact that he filed a motion to reconsider with the BIA after USCIS determined that yes, indeed, he was prima facie eligible for a U visa? The BIA and the 8th Circuit don't care much. And I simply cannot dispose of another argument in this case. Mr. Pacheco Moran lost. But then again, removal orders don't bar U visa grants, so there you go. He'll need a waiver, though, and he might have issues at adjustment, unsure. And of course, he is removable in the interim. But there's a path yet. Good luck, sir. And that is Pacheco Moran v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.